All right, I might open. Before we get to the changes, Teresa, can you give us a brief overview of what these laws are all about and maybe why the government has made these changes?
Sure, okay. So the unfair contract terms regime has actually been around for a while. In about 2010, it was introduced to help consumers, so ordinary people signing up to gym contracts, telecommunication contracts, making sure that there were protections for those sorts of consumers because they were having to enter into a contract and they had no ability to negotiate any of the terms. About 6 years later, it expanded to apply to small businesses. People started to take notice of this regime because it started to affect business contracts as well. It was only applicable to certain types of businesses, and they were small businesses, but quite small businesses. And recently, about a couple of weeks ago, that all changed, and now the regime has expanded to cover a lot more businesses, and has also changed in the context of how a breach of these laws will apply in the future. So just to give you a bit of a background, it doesn't relate to all contracts, just what's called a standard form contract. That's been the evolution of how the regime has come into play.
So if you were to categorise, so the laws have obviously just come into play. Mm-hmm. If you were to categorise, what are the main differences that have been applied to the new law?
Yeah. So the first main change that has occurred, that it has been the most fundamental, I guess, is that in the past, if you had a term of a contract that was unfair, it was up to you as the person who was subject to that unfair clause to take action and to see if you could have it declared void so that it would no longer apply to you. That was it. You couldn't really do anything else, such as seek damages or anything like that. And so it wasn't actually unlawful to have an unfair contract term put forward to you. And that has now changed. It is now against the law to include an unfair contract term in a standard form contract. So that's been a big change. The reason for the change, and you asked me earlier, why did the government want to change this? I guess the regime, as it stood, was seen as a little bit of a toothless tiger. Businesses were just saying, look, we'll just take the risk, who's going to go and challenge this? And if they do, okay, we can't rely on it, big deal. And so it didn't really have the impact that the laws were designed to deal with. So the main change is that now these terms are unlawful, and more than that, there are very severe penalties for having an unfair contract term in your contract. And when I say severe, they are frightening. And I'm not going to talk about that. I'm going to let Evan talk about that because he's scarier than I am, and he'll make you shake in your boots when you hear how scary they are indeed. Now, so this law the new changes came into play 12 months ago. But businesses had a 12-month window to try or to ensure that they got their house in order and updated all of their contracts. And most of them waited to the last month and made my hair turn grey. I luckily have had it done since then. But so there was a lot of people wanting to change their contracts to make sure that they're complying with the laws because of the changes and the penalty regimes that now apply.
Teresa, I often use this term with Mr. Jenkins. For those of us who don't speak law,
yes,
could you please explain what a standard form contract is?
Very happy to. So a standard form contract it does have a specific meaning. So when people think of the unfair contract terms regime, they think of it applying to big business and they're dealing with each other and, that now we can't have any contract terms that are unfair. It doesn't apply to all contracts. So it only applies to contracts that are of a standard form. And I talked about individual contracts, so gym contracts and telecommunication contracts are examples of ones that, this sort of started to try and counteract those contracts. But now what's meant by a standard form contract has a bit more of a broader meaning. And there isn't actually a meaning in the Australian consumer law, but it's taken to mean something where you're looking at two parties where one has more bargaining power than the other, where it's kind of given on a take it or leave it basis. And so often, you might even see this in a tender where, you have to put in a complying bid and you're not really allowed to negotiate any of the terms and conditions. So the lack of the ability to negotiate can often be a sign that you're dealing with a standard form contract. But what was going on during the period before it extended and these penalties applied was that businesses were saying, okay, we'll let you negotiate these not very important clauses, and as long as you don't touch these ones. And so the legislation has now addressed that and said that illusory negotiation won't be considered negotiation. So it really will apply to a lot more contracts now. And trying to sort of say, okay, we'll negotiate a little bit here and there, or add in a clause. What a lot of businesses were doing, were having a clause in the contract that said, you acknowledge that you've had the opportunity to negotiate and you just didn't want to, and that this isn't an unfair contract term type of contract, which doesn't really work. So that they're onto that now, and but having said that, where parties are negotiating a contract and they're freely doing that, that won't be considered a standard form contract.
This might be poignant to a number of members in our room. You mentioned that the definition of small business has changed.
Yes.
Has that applied to the definition of a consumer as well?
Yeah. So I'll just explain how the small business definition has changed. So I said earlier that in the old days of the UCT regime, a small business contract was one where it looked at the actual contract price. So if the contract price was $300,000 or less, or $1 million if it was more than a 12-month contract, you needed to satisfy that test first, and you also needed to have less than 20 employees. So that ruled out quite a number of businesses. Now that has changed so that a small business is anyone that employs less than 100 people. So So whereas the old test was the upfront price being $300,000 or less, or $1 million, and having 20 employees or less, now it's either having less than 100 employees or having an annual turnover of $10 million or less. So as you can see, that's expanded to a lot more businesses now. In terms of the consumer contract, so the definition of a consumer contract was a contract with an individual for the supply of goods or services, or granting them an interest in land. And the individual had to acquire the relevant goods or services for a personal, domestic or household use. So if they were acquiring something for a business purpose, then they couldn't avail themselves of the UCT regime. So quite a different test for consumers, and that hasn't changed under the new regime. It's only the small business test that has changed in the manner that I've said. And some of this was also picked up in the context of what was happening in the past also, was that sometimes a business may have entered into a contract using a subsidiary. And so they may have been a really large business, but the particular entity that they used to enter into the contract didn't employ anybody. And so, sometimes even big businesses could have inadvertently, I suppose, in terms of what the regime was really meant to protect small businesses, but it could sometimes impact large businesses as well. And that, with the new regime, that's particularly more pronounced given its application and people trying to now fall within it so that they can get certain terms struck out. And this came up actually in the parliamentary debates about the actual application of this, that this could be a consequence in terms of, really helping a large business when it was designed to assist a small business. And the ACCC, when they were sort of considering and putting in their submission, said that that didn't worry them. They actually want this to apply as broadly as possible. So it's an interesting one, and something to keep in mind when you're negotiating with businesses. You might think, oh, well, I'm dealing with a large business, so we don't need to worry about this regime. But it may be that the entity that they're using happens to be one where they don't have all of their employees in that entity, or have the turnover in that entity. So something to keep in mind.
Just a couple of points I picked up. There's a fairly comprehensive document that you guys have been kind enough to provide to us, that we will provide to all of the attendees of the event. One of the points I picked up, and I've written it down, so forgive me, I'm going to read it.
Okay.
You mentioned that a contract term may not be unfair if it is reasonably necessary to protect a legitimate interest of the party seeking to rely on it. Can you interpret that into layman's, please?
Yeah, sure. Okay, so this comes all up because we talked about we need to have a standard form contract. The other major part of it is that the term actually has to be unfair. And so there's 3 tests that you need to satisfy in order for something to be unfair. And I'll just go through them because one of them is the element that you've just asked about. And so the 3 tests are: there needs to be a significant imbalance between the parties in connection with the contract. So if there is one party who has the right to do something but the other party doesn't have the same right, that might be an indicator of an imbalance. If one party has a right but the other party hasn't given anything, and that party hasn't given up anything in relation to having that right, again, that might indicate an imbalance. There also needs to be detriment, so the party who's subject to the unfair term needs to suffer in some way by having it being put up upon them. The other one is, does the unfair term, it must not, if it goes beyond what is reasonably necessary to protect a legitimate interest, then that is also an indicator that it might be unfair. So what that means is that, do you have a legitimate reason why you need this unfair contract term in your contract? You might be unfair, there might be a significant imbalance, but you need to have that because your business can't run without that term. Now, it doesn't just sort of stop there. So you could say, okay, well, we are supplying you with goods and we're getting them from overseas, so there might be fluctuations in the exchange rate and we need to account for them. So we need to have a clause that allows us to change or vary our prices whenever this happens. Now, one party having the right to vary their prices when the other party doesn't have any other say in it could indicate that there's an imbalance, and obviously if that causes the party who's subject to the price variation to have to pay more, then we're looking like we've ticked off 2 of those 2 elements. But you could say, okay, well, we need to be able to vary these prices because otherwise, we're going to be subject to these fluctuations in the rates. Now, dealing with that and how you deal with that to demonstrate that you have a legitimate interest that you are protecting, you need to show that it doesn't go beyond that. So having a clause that basically just says in your contract, at any time we can vary our rates, that's not going to satisfy that test. So yes, you've got a legitimate interest, you can justify that, but having a clause that simply says we can vary our rates from time to time, but we know that we've got a really good reason why we need that, that's not going to pass muster. So you need to say something like, if there is a fluctuation in the exchange rates of more than X, then by written notice we will let you know, and then we will increase it to reflect that difference. That is very different to the first example that I just said, where you might say, okay, we've got a right to vary our prices and we've got a legitimate reason for that. That the first version of that goes beyond what it would be reasonably necessary to protect a legitimate interest. So something to keep in mind whenever you're thinking about, yes, I can justify this, but, is your contract going further than what it should be doing?
Another question, if you don't mind. Are there any clauses in particular that the ACCC have taken issue with when it comes to the new regime?
Yes, there are quite a few. Firstly, I should just say that the Australian consumer law has what's called the grey list, and it's called the grey list because for some reason they've put it in a grey box, and it is a list of all of the terms that they say will, potentially be unfair. And they give some examples of them. They're quite interesting, and I might just read them out to you. So ones are clauses where one party has the right to vary a price or vary the terms of the agreement. They will generally be considered examples of unfair terms or potentially unfair terms if we can't satisfy that legitimate interest test. Clauses that allow one party to terminate the agreement but not the other is another example. And often you see this in clauses in the agreement, in agreements where one party has the right to terminate for convenience and they say, oh, we need this, but the other party doesn't have that right. So that's potentially one. Clauses that allow one party to renew a contract but not the other. A party that limits the other party to sue them, so says you can't sue me, and often you will see that in limitation of liability clauses. Clauses that limit the vicarious liability for agents. So sometimes you might see a clause that says, if anyone enters into this agreement with you from that isn't authorised by us, we don't stand behind that. That's an example of a potential unfair contract term now, and that is quite a common clause that you see. Something that limits the evidence that can be adduced. Now, that's a really interesting one. And I always thought to myself, well, what does that actually mean? When do you ever see that in contracts? But it's actually quite a common clause, and even a clause that you might see as an entire agreement clause. So basically one that says, look, anything else that we might have said to one another, if it's not in this contract, you can't rely on it. And only the terms of this contract as they are in this contract apply to us. That is trying to limit the ability to adduce evidence about representations that may have been made outside of the contract. So that's called on as one of the potential unfair contract terms in this grey list. There are a few others as well, but the ACCC has gone further than that. So they haven't just limited their view of unfair contract terms to those. They have looked at other things, and one of the main ones on their hit list are automatic renewal clauses. So that's not where one party has the right but not the other. It's just that the contract might have a clause in it that automatically renews. And they've said that will generally benefit one party, and that's the party that's going to have the benefit of this renewing. And what we don't like about that is that it can cause detriment by the poor party being subject to this, or not subject to this, but not realising that the contract has renewed itself and ending up with a contract that they don't really want or need, and not being aware of it. So they have said, unless you have in your unless you make it really obvious and you remind the person that it's coming up, and that you make sure that the renewal term is shorter than the initial term, then we're going to declare that unfair. They've also looked at indemnity clauses in contracts and limitation of liability clauses, and they've talked about them being too broad. And one of the interesting things that they've said about limitations of liability clauses and indemnity clauses is they have said we don't like clauses that have the effect of a party being liable for someone else's negligence. So if you're the one that is they say you're the one that's most able to control that aspect, it isn't fair that you should be requiring someone to either indemnify you for your own negligence or to pick up the liability for your negligence. So there's some of the things that the ACCC has raised. So it's interesting that they haven't just stuck with what's in the Australian consumer law. They've gone much broader. So something to keep in mind.
You and your team have compiled a fairly comprehensive document for the MTAA. Oh, you've got an example of it there. There we go. Within that, it hosts a bunch of automotive-centric examples of what we're discussing here. Do you have any favourites you wouldn't mind sharing with the
as
room?
A matter of fact, yes, I do. So I've just picked 3 scenarios because I think they kind of, and we might not have time for 3, but I'll start with one. And then we can, hopefully I'll just go through what the scenario is, and then we'll go through our tests, our 3 tests, and see how they fare. So in one of the examples in the booklet is a car dealership called Cartown. They're one of the largest used car dealers in New South Wales. And when customers purchase a used car, they agree to Cartown's standard terms and conditions, which are attached to a sale contract. Young Tim has recently saved up enough money to buy his first car and sets off to Cartown hoping to find a good deal. Tim is flabbergasted when he sees his dream car, a used Ground Rover in mint condition and within his price range. Okay, maybe just a little bit over. Anyway, after going through the details with Bob, a Cartown salesperson, Tim pays a deposit, signs the sale contract and heads to the pub to celebrate his new purchase. Cartown tells Tim that he can pick up the car and pay the final instalment in a couple of weeks, once all the paperwork has been sorted. However, when Tim arrives to pick up his Ground Rover a couple of weeks later, he is confused to see that the remaining balance payable has increased by $500. Bob tells Tim that this is a 2% administration surcharge charged by Cartown and points Tim to the clause in the standard terms and conditions which state that Cartown may increase the price payable for the vehicle between the date of purchase and the date of delivery for any reason, including to pass through any costs incurred by Cartown and to apply any applicable surcharges that Cartown may determine from time to time. Tim is crushed and starts considering whether he even wants to proceed with the sale. Sensing some hesitation, Bob reminds Tim that the cooling off period has now ended and that there is no way for Tim to get out of buying this car. Okay, so let's just have a look at this example in terms of our 3-prong test. So is there a significant imbalance of rights here between Tim and Cartown? Well, we can see that Cartown has the ability to increase its prices in any way that they deem fit, and including for these surcharges and to deal with all of those things that they have in their contract term. But Tim isn't allowed to terminate the contract if he doesn't agree with the price increase. Is there a detriment that Tim suffers? Yes, there is. He's going to be liable for an extra $500. Now, is it reasonably necessary to protect Cartown's legitimate interests? Well, probably not, because the clause is so broad that it could allow Cartown to unilaterally vary prices for any reason. Example, Cartown could just use this clause to simply increase its profits. And this was raised in the case of JJ Richards, one of the waste disposal companies that was on the hit list when the ACCC first went out to look for its first scalp, I guess. It was looking at the waste industry and gave ample warning to people in the business to say, they're going to be investigating that area in particular. And they had a clause just like this that basically gave them the right to increase their prices for any reason whatsoever, including, for their own profits. So now that would obviously be dealt with this new penalty regime, which we'll talk about shortly. But that's one of our examples in the booklet. We might be running out of time for another, so I might let you get on with your other questions.
Well, we've now come to the business end, Evan. Teresa did mention you're the scary one, so can you tell us a little bit about the dramatic changes to the penalties and enforcement system associated with the new changes?
I will, thank you. And firstly, Stavros, thank you to you and your team for hosting this fabulous dinner. on behalf of the MTA. The work we are doing for on the unfair contractual term provisions is part of an initiative that's been undertaken by the MTAA. And as part of that initiative, Teresa and I, we're both from Melbourne. We've flown up to do this presentation, but we've actually done presentations right across the country to all the MTAs or the state associations. And this is the last one we're doing, and by far it's the largest, by far. So good on you, good on MTA New South Wales. And also, before I forget, apart from the booklet, the MTAA has also produced a video and which brings to life the examples, all of the examples that are in the booklet. And I have to say it's one of the best produced things I've seen from a legal perspective. And I really commend all of you to look at and have your staff look at it as well. It's an excellent training piece, and again, the MTAA should be congratulated for the effort they've put into to produce that video. So penalties. Okay, Teresa said the previous regime was a toothless tiger. She's probably right. Well, if the previous regime was a toothless tiger, well, this one's got shark's teeth and they're sharp. And most people, when they hear about this, they think, okay, this is great. How am I going to get protections for my business out of these unfair contractual term provisions? But you have to look at it from the other perspective as well. Like, in particular, what if my business has an unfair contractual term regime? How will this affect me? What will happen if I'm caught out? And the consequences are serious. So if you're a corporation, it's the greater of, right? So it's the greater of $50 million, these are maximum penalties now, up $50 million, or 3 times the benefit obtained, or 30% of the adjusted turnover for the period of the breach. So the adjusted turnover looks 12 months back from when the breach occurred and takes 30% of that turnover. So the maximum penalty is the greater of that. So the maximum penalty, at the very least, will be $50 million for a corporation. It's a lot of money. And if you're an individual, the maximum penalty is $2.5 million. Again, it's a lot of money. And it's not just entering into a contract, merely proposing a contract, offering a contract to somebody that has an unfair contractual term is an offence. So, for example, in your businesses, let's just say you're running a motor repair shop, and someone comes in to have their vehicle repaired, for argument's sake, and you say to them, sign that contract. This is our standard contract, please sign it. And they look at that contract and say, well, hang on, there's a clause in there that I think is unfair. That alone can give rise to a penalty if you are prosecuted and it's found to be an unfair contractual term. The mere proposing, not just entering into a contract. Take this seriously. I can tell you the biggest show in town in law firms is reviewing contracts at the moment. That's what all law firms are doing at every level. They're reviewing contracts with their clients to determine whether they're standard form contracts and whether they have unfair contractual terms. If your business has a standard form contract, then I urge all of you, at the end of this function, go back to your offices, go back to your businesses, have a look at your contracts. Are they standard form contracts? And if they are, you must get them reviewed. If you get your contracts through an association, then talk to your association and have them looked at. But doing nothing is not a good idea at the moment. I might also just quickly, if you don't mind, talk about, well, where does this legislation fit in the bigger scheme of protections for the motor trades industries, to give you a bit of perspective of where this, what context you can give this. So apart from the unfair contractual term provisions, there's the franchising code. Now, the franchising code has what is called an obligation of good faith. So there has to be good faith between the parties, and one of the obligations of good faith in the contract, in the franchising code, is the court can take into account whether the terms of a contract are fair and reasonable. Sounds a bit like unfair contractual terms, but it only applies to franchisees. So if you're not a franchisee, you take no advantage, you get no benefit from that. The other protection is offered under the Motor Vehicle Dealers and Repairers Act, and this is the New South Wales Act. And this act is, every state has its own equivalent act. The New South Wales Act is unique. unlike any other state act because it actually prohibits unjust conduct and unfair contractual terms. None of the other state acts have that provision in there, that protection in there. But again, that only protects you if you're a motor vehicle dealer and nobody else, and only if you're from New South Wales, if you have that benefit. And I can tell you, everyone else in every other state is very envious of that legislation. And the final protection is what's found in the Australian Consumer Law, which is the protection against unconscionable conduct. You may have heard of that term before, but unconscionable conduct is something that's not really defined. There's things that the court can take into account when considering whether something's unconscionable, but otherwise it's undefined. But what the courts say, it's probably the worst of the worst corporate conduct, and it's got to be something that's more than just unfair, more than just unjust, and more than just harsh. And to give you an example of how difficult it is to prove unconscionable conduct, I'll refer you to the recent Mercedes-Benz case. I mean, you may be aware of that case. That's where the Mercedes-Benz dealers in Australia were all motor vehicle dealers operating independent businesses as franchisees. And one day Mercedes-Benz in Australia turned around and said, we're not renewing your contracts anymore. And by the way, if you want to continue with us, you have to sign this agency agreement. Now, under the agency agreement, all the customers that were once belonged to the franchisee now belong to Mercedes-Benz. They just sell the cars that Mercedes-Benz owns on behalf of Mercedes-Benz, and they get a commission. And the commission they get is really just almost is very low compared to what they got before, which has a severe detrimental effect to the goodwill of their business, because the goodwill of the business is based on a multiple of the turnover or the revenue of their business. So there's been a big reduction in the value of their businesses, and these businesses are worth millions. So what's happened in effect is Mercedes-Benz has taken the benefit of their goodwill and paid no compensation to the dealers. Now, the judge in that case agreed that Mercedes-Benz engaged in what he called franchisor opportunism. He said that the dealers were at a disadvantage. He said that they had no real choice in entering into the contracts. He said there was no real negotiation involved in the contracts. He acknowledged that the profit or the commission that they get was much lower than they previously got. And despite all of that, he said, and by the way, I don't think it's unconscionable conduct. Just so he give you an idea how hard it is to prove unconscionable conduct. And the other thing he said is, and the franchising code has no protections at all, no protections for goodwill of a franchisee. So the timing of that case is very interesting because as it just happens, when that case was handed down, the judge did say, and the franchising code needs a reform with respect to protecting goodwill. And as that case was handed down, just happened to be when the federal government is undertaking a review of the franchising code. And the MTAA has put in a very detailed submission for reform. And one of the things that they've said and strongly advocated for is protection of goodwill, and that the protection that all New South Wales dealers get under the Motor Vehicle Dealers and Repairers Act should apply to all franchisees under the franchising code.
So a big round of applause for Teresa and Evan. Thank you so much.